If you received your green card in the last few years, or if you know someone who did, this video contains information that could determine whether that green card stays valid or gets revoked. Just 2 days ago, on April 19, 2026, USCIS Director Joseph Edlow made a statement that has sent shockwaves through the immigration community. He announced that USCIS is going back and rechecking old green card cases, not future applications, not pending cases, old cases, cases that were already approved, cases where people thought the process was finished and their status was secure. That assumption is no longer safe. In his exact words, Director Edlow said, "We are looking at old cases. We are going back and revetting cases for people who were granted green cards and other benefits during the Biden administration when there was no vetting." He went further and directly addressed anyone who committed fraud. People who are perpetrating fraud, stop, because we are going to find you. If you have already done it and you think you have gotten away with it, we are going back. This is not a rumor. This is not speculation from social media. This is a direct public statement from the director of USCIS, the agency that issues green cards. And in this video, I am going to explain exactly what this means, who is at risk, what USCIS is actually looking for, what legal authority they have to reopen approved cases, the new tip lines and armed special agents they are deploying, and most importantly, the specific steps you need to take right now to protect yourself if you have any concern about your immigration history. Stay until the very end, because I am going to explain a new tool USCIS is using that most people do not even know exists yet. Let me start with what exactly USCIS announced. Director Joseph Edlow's statement was posted publicly on the official USCIS social media accounts and was covered by Business Standard, Times of India, Hindustan Times, and several other major outlets within hours. The statement contained 3 distinct components that you need to understand separately. The first component is the retrospective case review. USCIS is going back through green card cases and other immigration benefits that were approved during the Biden administration, which covers cases approved from January 2021 through January 2025. Edlow specifically stated that these cases were approved when there was no vetting, implying that the current administration believes the previous administration's screening processes were insufficient. Whether you agree with that characterization or not is irrelevant. What matters is that USCIS has the legal authority to reopen these cases, and they have publicly stated their intention to do so. The second component is the fraud tip lines. USCIS is preparing to open multiple tip lines where anyone can report suspected immigration fraud. Director Edlow said, "No tip is too small. We will look into it along with our partners at ICE and with CBP." This means USCIS, ICE, and CBP will be working together to investigate fraud tips. The implications of this are enormous because it means a disgruntled ex-spouse, a jealous neighbor, a former business partner, or anyone with a grievance could file a tip that triggers a full investigation into your immigration case. The third component is the public charge enforcement. Edlow made it clear that financial self-sufficiency is a central factor in green card eligibility going forward and retroactively. His exact words were, "We want people to come to this country who can take care of themselves and are not going to be drains on the public coffers. If you cannot pay for yourself and take care of yourself, you are not going to get a green card in this country." While this was framed as a forward-looking statement, in the context of rechecking old cases, it suggests that USCIS may also be examining whether previously approved applicants have become public charges since receiving their green cards. Now let me explain the legal authority USCIS has to reopen approved cases, because many people believe that once a green card is approved, it is permanent and cannot be taken away. That belief is dangerously wrong. Under Section 237 of the Immigration and Nationality Act, a lawful permanent resident can be placed in removal proceedings and deported on several grounds. The most relevant ones for this situation are fraud or misrepresentation of material fact at the time of admission or adjustment of status, criminal convictions including crimes involving moral turpitude, becoming a public charge within 5 years of admission, and violations of the conditions of admission. The fraud ground is the one that USCIS is primarily focused on with this announcement. If USCIS determines that you obtained your green card through fraud, whether it was marriage fraud, employment fraud, document fraud, or any other type of misrepresentation, they have the legal authority to revoke your green card and initiate removal proceedings, regardless of how many years ago the case was approved. In February 2026, the Board of Immigration Appeals issued a significant decision in matter of Gin, 29 INN Decarn 441, which specifically addressed the reopening of approved visa petitions based on allegations of marriage fraud. This decision confirmed that immigration authorities can return cases for further review when there is evidence or allegations of fraud, even after the petition was originally approved. This legal precedent is now being used as a framework for the broader review that Director Edlow announced. USCIS also has the authority under 8 CFR 205.2 to revoke the approval of an immigrant visa petition at any time if the director finds that the approval was obtained through fraud or was not justified. This regulation has existed for decades, but has rarely been used aggressively until now. Let me now explain who is most at risk from this review. While Director Edlow framed the review broadly as covering all Biden-era approvals, immigration attorneys believe that certain categories of green card holders will receive the most scrutiny. The highest risk category is marriage-based green card holders. Marriage fraud is the single largest category of immigration fraud prosecuted in the United States. In February 2026, USCIS assisted in a marriage fraud conspiracy investigation in Jacksonville, Florida, that resulted in 11 indictments. Cases like this are exactly what USCIS will be looking for as it reviews old files. If you obtained your green card through marriage, USCIS may review whether the marriage was genuine by examining your joint tax returns, your shared address history, your financial commingling, whether you and your spouse actually lived together, and whether there are any indicators that the marriage was entered into primarily for immigration purposes. The second high-risk category is asylum-based green card holders. USCIS has been reviewing refugee and asylum cases for months, particularly from specific regions and time periods where fraud concerns have been raised. If you received asylum and then adjusted to permanent resident status, your original asylum claim could be re-examined for inconsistencies, fabricated evidence, or claims that no longer align with country conditions at the time you applied. The third high-risk category is employment-based green card holders, where the sponsoring employer no longer exists, where the job described in the petition never materialized, where the wages paid were significantly lower than what was stated in the labor certification, or where the employer was later found to be a shell company or a fraud operation. USCIS has access to wage records through the Social Security Administration and can cross-reference what was promised in your petition with what was actually paid. The fourth high-risk category is diversity visa lottery winners. The DV lottery has historically been a target for fraud investigations because of the relatively simple application process and the volume of applications. USCIS may be reviewing whether lottery winners met the education or work experience requirements they claimed, whether identity documents were authentic, and whether there were any misrepresentations on the application. The fifth high-risk category is anyone who used a known fraud facilitator. If you used an immigration consultant, notario, or attorney who was later indicted or convicted for immigration fraud, USCIS may reopen every case that individual handled. Even if you personally did not commit fraud, if your case was processed by someone who did, your file may be flagged for review. Now let me explain the new enforcement tools that USCIS has at its disposal in 2026 that it did not have before. The most significant development is that USCIS now has its own armed law enforcement unit. On September 4, 2025, USCIS announced that it would deploy its own special agents authorized to carry firearms, execute warrants, make arrests, and initiate investigations in both civil and criminal immigration cases. This is historically unprecedented. USCIS was always the benefits-granting agency, the agency that processed applications and issued green cards and work permits. Enforcement was left to ICE and CBP. That distinction no longer exists. USCIS now has its own investigators who can knock on your door, ask you questions, review your documents, and arrest you if they find evidence of fraud. Director Edlow emphasized this change directly. With new special agents on board, the agency is on its way to opening multiple tip lines where people can report immigration fraud. The combination of armed agents and public tip lines creates a system where anyone can report you, USCIS can investigate you, and USCIS can arrest you, all without involving ICE at the initial stages. The second new tool is the Enhanced Screening and Vetting Framework announced on March 30, 2026. USCIS published a public update confirming that it has reviewed and updated its screening and vetting practices over the past several months. This includes enhanced background checks, expanded social media reviews, country-based hold frameworks for certain nationalities, and procedures to lift or maintain holds on pending cases. While this framework was initially described as applying to new applications, Director Edlow's April 19th statement makes clear that these enhanced vetting tools are also being applied retroactively to previously approved cases. The third new tool is the interagency collaboration between USCIS, ICE, and CBP. Director Edlow specifically said the tip lines would be operated, along with our partners at ICE and with CBP. This means information flows freely between the three agencies. A tip submitted to USCIS can trigger an ICE investigation. A CBP encounter at the airport can trigger a USCIS case review. A USCIS case review can result in an ICE arrest. The agencies are now operating as an integrated enforcement system rather than separate silos. The fourth new tool is the denaturalization pipeline. The Trump administration has set a target of 100 to 200 denaturalization case referrals per month to the Department of Justice, potentially reaching up to 2,400 cases per year. This means that even if you have already become a U.S. citizen through naturalization, your citizenship can be stripped if the government determines that the underlying green card was obtained through fraud. On March 31, 2026, Reuters reported that the government stripped citizenship from a California couple who emigrated from China as part of this expanded denaturalization push. If the green card that formed the basis of your citizenship was fraudulently obtained, your citizenship is at risk too. Now let me address what you should do if you are concerned about your case, and I want to be very clear about something first. If you obtained your green card legitimately, if you told the truth on your applications, if your marriage is genuine, if your employment was real, if your documents are authentic, then you should not panic. The review is focused on fraud, but even legitimate green card holders need to take steps to protect themselves because mistakes, incomplete records, and inconsistencies can be misinterpreted as fraud indicators. The first thing you should do is locate and organize every document related to your immigration case. This means your original application, all supporting documents you submitted, all USCIS receipts and approval notices, all correspondence with USCIS, and any documents your attorney submitted on your behalf. If you used an attorney or consultant, contact them and request a complete copy of your file. You need to know exactly what was submitted in your name, because you are responsible for the contents of your application, even if someone else prepared it. The second thing you should do is review your application for any inconsistencies or errors. Compare what was stated in your application with your actual history. Are the dates accurate? Are the addresses correct? Is the employment history consistent with your tax returns and wage records? Is your marriage-based evidence consistent with your actual living situation at the time? If there are discrepancies, even innocent ones, you need to be aware of them before USCIS discovers them. The third thing you should do is ensure your tax records are in order. USCIS has access to IRS tax transcripts and can cross-reference your tax filings with your immigration applications. If you claim to be married filing jointly, but your tax returns show married filing separately, that is a red flag. If your income does not match what was stated in your employment-based petition, that is a red flag. If you have unfiled tax returns during the period of your green card application, that is a red flag. File any outstanding returns and resolve any discrepancies before USCIS finds them. The fourth thing you should do is review your social media accounts. USCIS expanded social media vetting on March 30, 2026 to cover 14 additional visa categories. If your social media tells a different story than your immigration application, clean it up. Photos showing you living in another country while claiming U.S. residence, posts celebrating a relationship that contradicts your marriage-based application, or any content that could suggest fraud should be addressed with an attorney. The fifth thing you should do, and this is the most important step, is consult an immigration attorney now, before USCIS contacts you. If you receive a notice from USCIS that your case is being reviewed, that is not the time to start looking for a lawyer. That is the time to already have one. An experienced immigration attorney can review your file, identify potential vulnerabilities, prepare explanations for any inconsistencies, and represent you if USCIS initiates proceedings. Find an attorney through the American Immigration Lawyers Association at aila.org, find an attorney, or through lawhelp.org for free or low-cost services. If you are contacted by USCIS about your case, do not ignore the notice. Do not miss any scheduled interviews or appointments. Do not provide false information. And do not speak to investigators without legal counsel. You have the right to be represented by an attorney in any interaction with USCIS, and you should exercise that right. Let me address a question that many people have asked since this announcement. Can USCIS really take away a green card that was approved years ago? The answer is yes. There is no statute of limitations on immigration fraud. USCIS can reopen a case 5 years, 10 years, or 20 years after it was approved if they discover that the approval was based on fraud or misrepresentation. The Immigration and Nationality Act does not set a time limit on fraud-based revocation. This means that even if you received your green card in 2021, 2022, 2023, or 2024, and you have been living as a lawful permanent resident for years, your case can be reopened. However, and this is important, USCIS must have a basis for reopening your case. They cannot randomly select approved cases and revoke them without evidence or allegations of fraud. The review will be driven by data analysis, cross-referencing databases, fraud tips from the new tip lines, information from other agencies like ICE and CBP, and patterns identified by USCIS investigators. If your case was clean, the probability of it being selected for review is lower, but not zero. Let me give you the critical numbers and facts you need to remember. USCIS Director Joseph Edlow publicly announced the retrospective case review on April 19, 2026. The review targets green card cases and other benefits approved during the Biden administration from January 2021 through January 2025. USCIS has deployed armed special agents since September 4, 2025, with authority to carry firearms, execute warrants, and make arrests. Multiple fraud tip lines are being established in coordination with ICE and CBP. The denaturalization target is 100 to 200 cases per month, or up to 2,400 per year. Enhanced screening and vetting procedures were updated on March 30, 2026. The USCIS special agents can investigate both civil and criminal immigration violations. There is no statute of limitations on immigration fraud. Marriage fraud remains the most commonly prosecuted form of immigration fraud. The USCIS Contact Center is 1-800-375-5283. The AILA lawyer referral is at aila.org, find an attorney. Let me put this in context. What we are witnessing is a fundamental transformation of USCIS from a benefits-granting agency into a hybrid benefits and enforcement agency. For decades, USCIS processed applications, approved benefits, and left enforcement to ICE. That model is over. USCIS now has its own investigators, its own armed agents, its own arrest authority, and its own mandate to go back through years of approved cases looking for fraud. This does not mean every green card holder should be afraid. The vast majority of green cards were obtained legitimately, and the vast majority of those cases will never be touched. But it does mean that the era of assuming an approved green card is permanent and untouchable is over. It means that anyone who cut corners, anyone who exaggerated on their application, anyone who used a fraudulent document, anyone who entered a sham marriage, and anyone who relied on a dishonest consultant is now in genuine danger. And it means that even honest green card holders need to be prepared. Because in an environment where anyone can file a tip, where USCIS has armed investigators, and where old cases are being reopened, the best protection is documentation, honesty, and legal counsel. If this video helped you, hit the like button, subscribe to the channel, and share this with every green card holder you know. This is breaking news that affects millions of people, and most of them do not know about it yet. Drop a comment below and tell me whether you are concerned about your case. I read every single comment, and I will do my best to answer your questions. Stay informed, stay prepared, stay safe. I will see you in the next one.